thank you very much for the invitation to speak at this event. I'm only very sorry I can't visit Cork again. I've thoroughly enjoyed my visits there in the past. My title, as you see, is New Environmental Watchdogs in Post-Brexit UK. And post-Brexit UK is, of course, only a few days away from us. Just to start with a bit about the general position as far as Brexit and continuity of the law is concerned. The UK formally left the European Union on the 31st of January this year, but at present we're in the transition or implementation period, which lasts until the end of December this year. And during that period, essentially, there's very little change. What's going to happen after the 31st of December? Well, when I first wrote a paper vaguely along these lines months ago, there was a whole series of question marks. When I wrote this paper a couple of weeks ago, I thought, well, I'll leave the question marks in, but by the time I come to speak, obviously things will be sorted out. There are still the question marks there. We still don't know exactly what's going to happen in only a few weeks' time. This has been, to say the least, somewhat frustrating and not a great example of good governance in many ways. In talking about the post-Brexit world, the other background issue that needs to be mentioned is the devolution dimension. Environmental law in the UK is a heavily devolved area. Most environmental matters are dealt with by the Scottish, the Welsh, the Northern Ireland government and the UK government looking at England only, rather than being controlled directly by the UK government. But there's a clear interplay between the devolved responsibility for environmental matters and things that are being dealt with at the level of the UK internal market through the internal market bill that going through, and the impact of obligations that the United Kingdom government may make in international trade agreements, implications which may constrain, may limit what the devolved administrations can do. They may have to accept things that they would not otherwise be happy with. So there's the devolved side to think about. Now, as far as environmental law post-Brexit is concerned, the basic position under the withdrawal situation is that existing EU law and all domestic law based on it is rolled over and continues in effect as law across the United Kingdom. And that includes the case law of the Court of Justice. It remains as binding legal authority across the UK. This law becomes what's known as retained EU law, the special status of retained EU law, governed by the two acts you can see there if you want to follow it up more closely. And since in the last few years, there have been many, many detailed amendments to remove reference to the role of EU bodies, to remove references to the EU and its processes from the domestic law, from the law that's going to continue enforced at the end of this month. If you are ever wanting to see examples of the most boring legislation possible, I recommend some of these amending measures, 100 or more detailed amendments to fishing regulations where EU is scored out and something else is put in its place instead. Not the most exciting reading, even by legislative standards. As far as that retained EU law is concerned, once the UK is at the end of the implementation, the transition period, that law clearly is now amenable, vulnerable to change at the UK level. The 2018 Act gave the ministers wide power to do this by regulations, to deal with any failure of EU retained law to operate efficiently or with any other deficiency in the law. Also, of course, it can be changed by ordinary legislation. There's no limitation to have to follow the EU rules, subject, of course, to any level playing field agreement that may or may not be reached this week or next week or and then the week after, and subject, of course, to what the terms of that level playing field agreement actually are in relation to environmental matters. As far as case law is concerned, the case law from the European Court remains binding, but it can be departed from. Now, under the 2018 Act, European case law could be overridden only by the Supreme Court. It could only depart from Court of Justice decisions on the same basis as it is prepared to depart from its own decisions. That's a very rare occurrence. But under the 2020 Act, introduced by the Boris Johnson's government, regulations are going to be made to allow appeal courts to do the same as well. So the Court of Appeal in England, the Northern Ireland Court of Appeal, Inner House of the Court of Session. So EU case law is going to become much more vulnerable in future in the UK once these regulations are made and a wider range of courts can change the position. So the law's carrying over, but what isn't carried over is the sense of accountability. One of the major losses as a result of Brexit is accountability of the UK government, the devolved governments, for their environmental performance. There's a loss of the European Commission's oversight. We've just been hearing how much attention the Commission pays to what's happening in individual member states. And ultimately, there's the loss of the court's power to compel compliance and impose sanctions on member state governments for not living up to their environmental obligations. And in addition to those formal, those headline processes, there's also the more general oversight and accountability that's brought by being a member of the European Union. The routine overview of what's happening through the various reporting requirements built into directives, the fact that the Commission offers a cost-free route for complaints, the fact that the Commission will deal with lots of cases informally that never actually get to the reasoned opinion, the court stage. So you're losing all that accountability. You still have the laws in place. You still have the laws derived from the EU that impose obligations, targets on the UK, the devolved governments to do things. But that's not a style of accountability. It's not a framework not a legal framework that we're accustomed to in the UK system. We don't have a tradition of having duties placed on government to meet targets. This was discussed in relation to the Climate Change Act. I know Ireland's also discussing revising climate change issues. And it's still not altogether clear that although targets are described as legal targets, what actually happens if the target is not met? Who can raise an action? Who can sue in relation to a failure to meet the target? At what stage can they do it? Do you have to wait until the target has actually been missed, or can you do it in advance? And what's the remedy if you do bring an action? So we're not altogether clear what's happening in relation to these targets. So the loss of accountability identified as a major issue, and somewhat to people's surprise, given the rhetoric at the time of the referendum, the government has accepted, the various governments have accepted that there does need to be some new mechanism put in place to ensure environmental accountability. But because this is a devolved matter, different things are happening in the different parts of the United Kingdom. In England, there is going to be the Office of Environmental Protection. That is provided for in the Environment Bill. That bill also does a lot more. It has substantive measures on environmental principles. It has rules on changes to the law on air, water, waste, resource efficiency, biodiversity, net gain, and conservation covenants, requiring new development to have conservation gains and so on. Northern Ireland is going to be covered by the Office for Environmental Protection as well. That's largely because while all of this was being discussed, Northern Ireland didn't have a government or assembly. So if anything was going to happen, going in with the OEP was the only real option. Scotland is going to have a separate body called Environmental Standards Scotland. That is also currently being legislated for in the UK withdrawal from the European Union Continuity Scotland Bill. And that bill doesn't have other substantive environmental measures, but it does have two important other elements to it. One is providing for environmental principles to be part of the law of Scotland, and the other to provide a wide power for the Scottish government to keep in step with EU laws. Contrary to the UK government, the Scottish government's policy is to remain in step with EU law, dynamic alignment. So this bill is giving it a wide power to legislate to achieve that, rather than leaving it fragmented in different bits of legislation. Wales, also a very different environmental governance structure because of legislation passed earlier this decade. What it has decided is that the legislative measures are going to be deferred until after the May 2021 elections, but it is appointing an interim environmental protection assessor, a platform whereby possible instances of failure to implement or non-compliance with environmental law in Wales may be reported. So there will be legislation in future, but to begin with, it's a non-statutory process in Wales. So things are happening in relation to oversight, but what's happening, various challenges, various issues that arise. There's obviously a question of independence. If you're having oversight of the government, how do you secure independence? Well, clearly it's impossible to match what the EU can provide, this external powerful body, but you want to try and guarantee independence. There are issues about resources and capacity. What's the role of the oversight body? Is it just looking at complaints? Does it have an advisory function? Is it only looking at non-compliance or wider issues? What's the scope of its responsibilities? How accessible is it going to be compared to the easy access to the Commission, very different from costs of legal actions? What are the remedies the body is going to have, and how's it going to work with EU and other international bodies? So, say something very quickly about some of these in relation to the different parts of the United Kingdom. So, in England, you're going to have this Office for Environmental Protection, and it's going to have a range of functions, a number of functions. It's going to be responsible for monitoring progress on the environmental improvement plans and environmental targets, which are also being introduced through the Environment Bill. It'll have a role in giving advice to government. It has a role in monitoring the implementation of environmental law, defined in this context in terms of legislative provisions. So it's not going to look at international obligations, it's just going to be domestic law. And it also has oversight of non-compliance with environmental law. And in carrying out its functions, it's said that it must act objectively and impartially. Oh, sorry, I just noticed that double act there, my apologies. Must act objectively and impartially, and with regard to the need to act proportionately and transparently. Proportionately is something that's being stressed by the government. This is a backstop, a very much an oversight body to deal with big issues rather than to interfere all the time with environmental decisions. Questions have been raised about the independence of this new office. It's appointed by the Secretary of State, and a late addition to the bill is that the Secretary of State can issue guidance on its enforcement policy and functions, guidance that the OEP must have regard to. So there's concern that the government not only is controlling appointments, but has a degree of control over what the body is going to do with the functions, how it's going to go about its task. There is, in terms of resources, the duty on the Secretary of State to pay such sums as are considered reasonably sufficient to enable it to carry out its functions. In terms of scope, it can look at climate matters, but it's meant to have a memorandum of understanding with the Committee on Climate Change to make sure they work efficiently together and don't overlap. And central to what the OEP is going to be doing, it must produce a strategy setting out how it's going to prioritise, how it's going to deal with different aspects of its task. Northern Ireland is going to be looked after by the OEP as well. So devolved matters in Northern Ireland will be looked at by the OEP. Essentially the structure the same as for England. There's going to be one Northern Ireland member appointed by the Northern Ireland government, and either by agreement or consultation, the Northern Ireland government's going to have a role in appointments. Northern Ireland government's going to contribute to resources as well, but there's no power at present, at least, for the Northern Ireland government to issue guidance to the OEP in relation to the exercise of its functions in Northern Ireland. But of course, in talking about the Northern Ireland position, should also mention that the deal that re-established the Northern Ireland Assembly and Government promises an independent environment agency outside the government department. So as well as having the OEP, there may be other changes in Northern Ireland there. When it comes to the OEP operating in England or in Northern Ireland, in terms of enforcement, it will be able to act on its own initiative or in receipt of complaints from the public of serious failures by a public authority to comply with environmental law. It has a power to seek information, an information notice, simply to get more information. It then has the power to issue a decision notice where it's satisfied on the balance of probabilities that there is a failure to comply with environmental law and that failure is serious. The decision notice sets out the steps required to remedy, mitigate, or prevent a reoccurrence of the issue, and the authority in question must respond within 2 months. If it doesn't respond, what the OEP can do is have recourse to an environmental review. It can refer to a court the original conduct of the authority to test whether or not the authority was in breach. The court can then produce a statement of non-compliance, essentially a declaration of non-compliance. But in doing this, it has to apply standard judicial review principles, and it's limited to the standard judicial review remedies, but not to damages. So there's no power for the courts in England or in Northern Ireland to impose penalties, to impose sanctions as a result of non-compliance, although the OAP can go directly to judicial review in urgent and serious cases. So the OAP, the plan is that the decision notice will really be the main remedy. If that doesn't produce the goods, it can go to court, but it's really an enhanced form of judicial review only. Scotland gone down a rather different line. The new body, Environmental Standards Scotland, is going to have the function of monitoring compliance with environmental law and also the effectiveness of environmental law and how it's implemented. And for Scotland, that does include implementation of international obligations. A feature, though, of the Scottish legislation is that, again, they're keen that Environmental Standards Scotland becomes an oversight body, not another level of appeal, not another place disgruntled people go to. So you have there the provision from the statute that it shouldn't deal with particular instances. It shouldn't deal with the exercise of regulatory functions in relation to a particular person or case. So it's not there to be an appeal from a decision to take or not to take enforcement action, not there to be a further appeal against the grant or refusal of a license. Again, issues about independence. Environmental Standards Scotland will be appointed by the Scottish ministers, but here, crucially, it is to be with approval of the Scottish Parliament. So it's not just the ministers, they've got to get the approval of the Scottish Parliament as well. And there are express provisions for initial non-statutory appointees to be carried over. There is currently a recruitment process going on to have a preliminary, a proto-Environmental Standards Scotland created that can be rolled over into the statutory body without having to go through all the hoops again. There's also in the legislation an express provision that it's not going to be subject to the direction or control of government or ministers, but that is, as always, subject to a little provision that says unless the contrary is provided. That's generated a lot of excitement. The government says this is just so they can provide guidance on budgeting and audit matters. Obviously, other people are more concerned that the government's creating a loophole for itself in future. Again, the body must produce a strategy that will help to guide, to show how it's going to carry out its functions, how it's going to prioritise things. In Scotland, another controversial issue that's created debate, the scope of Environmental Standards Scotland does not extend to deal with climate change targets. The government's view is that with the Committee on Climate Change, the parliamentary procedures systems already in place to deal with that, it would be a duplication for ESS to look at these matters as well. When it comes to enforcement, again, there's a power for ESS to gain information. Here, though, backed up by the power to refer non-compliance to the court, where it will be treated as a contempt of court. The initial tool that the ESS can use are improvement reports, either on the basis of non-compliance with the law or simply a lack of effectiveness of the law. ESS can make an improvement report to the Scottish ministers, who must publish the report and then respond to it by producing an improvement plan that deals with the issue involved. That plan can be rejected by the Scottish Parliament. That the plan must set out what's going to be done, monitoring timescales and so on. If the Scottish Parliament isn't happy with it, it can reject it, send it back to the ministers, who have to produce a revised plan that they are happy with. ESS also has this potential to produce a compliance notice, where there is a failure to comply with environmental law and it's continuing or may be repeated and causes actual or likely environmental harm. A compliance notice can be served telling the public authority it's in breach, telling what it has to do to put things right. The authority who receives this can appeal to the Sheriff Court about it, but then if they don't comply, a failure to comply is referred to the Court of Session, where again it can be dealt with as a contempt of court. So there's the potential that a public authority who doesn't comply with a compliance notice being dragged before the court and subject to the substantial powers that the court has to enforce contempt of court. And again, there's a background power to seek judicial review in serious cases. So you have in the Scottish structure a much more powerful body, one that is looking both at the improvement of environmental law and requiring ministers to do things to tidy up, to put things right, and the compliance notice much more directly, much more powerfully telling public authorities to put things right and to set their house in order. So what does all this mean for the future? Well, it's hugely welcome that something is being done to fill what was identified as a big gap following Brexit, this lack of accountability. Now, obviously, nothing that happens within the internal UK system can replace the power of the UK institutions, but something is being done. There are, however, notable differences across the UK with a much stronger enforcement power in Scotland. Concerns, as there always will be, over the extent of ministerial influence. How do you actually set up a public body that is genuinely independent, that genuinely can call government to account, but particular worries in England with the possibility for ministerial guidance. And in reality, a lot will depend on culture and approach rather than direct powers. The intention is to allow for informal resolution of a lot of matters, to hope that the formal powers of the OEP and the ESS rarely get used to make sure that things can be done informally. But that all depends on how governments and public authorities react. How serious are they about delivering on their environmental rhetoric? Will these watchdogs actually be powerful, influential bodies that are taken seriously, or will they be undermined? Will they be pushed away as far as possible? Only time will tell, slightly longer time than will tell in terms of whether we actually have a Brexit deal or not. And I can finally, after 4 far too long years, actually start talking about something else. Thank you very much.